It is April 28th of 2026, and this is the Court Gallery. Today we're covering a wide range of intense hearings. First up, Judge Gauthier loses all patience with a woman who hasn't paid a penny on her fines. Then we see a defendant with a long history of fraud get called out by Judge Gauthier for being dishonest right in the courtroom. We'll also see defendants crumbling as Judge Boyd explains the facts of life to them. And the drama shifts to family court, where we're checking back in on a family that can't stop being toxic with each other, and Judge Satterfield is tired of it. After that, Judge Mogan has two defendants to deal with, a deadbeat and a man who won't stop starting fights with his brother. Buckle up, ladies and gentlemen. It's been a crazy day in court, and it all starts right now. It is April 28th of 2026, and this is the Court Gallery.
Five 693FH. Okay. All right. Good afternoon, Ms. Kuba. All right. So let's see. We adjourned this out to see if you were making payments, but you didn't make it. What's going
Well,
on?
I'm going to set I plan on setting it up today. I get paid at 4. But so I don't know if I told you this at the last hearing. I have a seasonal. My high paying job is seasonal. It did just start up, and so I haven't been paid yet from that, but I plan on setting up my regular payment plan that I was on before and just following it out for today.
Stephanie, so we had you in court in early February,
Yes,
and I adjourned it out. And you've not paid a penny since
I
then?
have not. Well, so I have a $550 card agreement. I have $300 insurance. I have my $100 phone bill. I have my son's phone bill, and I work at Myers during the winter. I haven't had a check of more than $250 in probably all winter. Trust me, I'm struggling right now. I owe my mom $200. I'm like, but like I said, the season has started. I'm already back in, so.
The last payment was last October.
I know I can do what I can do, though.
Well, I understand that. Believe me, I understand that. But here's where I'm coming from is you could have done better than zero. I mean,
Not really, I mean.
you're telling me you haven't smoked a single cigarette or drank a single Red Bull since October? Of course not. So you could have come up and put $5 down or $10 down here and there, and you haven't done it. So you have done nothing.
I know. I do smoke cigarettes though.
Yeah, those are a lot. Man, it's really tempting to just find you in contempt today for that complete lack of effort. But I don't want to, I mean, you got the job. I want that to go well. Any input, Ms. Goodrich?
That may be helpful to come back on May 26th.
Yeah. All right, Stephanie, you're gonna have to come back to court in a month on May 26th at 3 p.m. And I'm telling you what, I do not like to give people jail on fines and costs, show causes. You are in the neighborhood. Okay. I need to see you make an effort.
I'm gonna make a payment today.
Okay.
Is there like a certain amount I need to pay by then?
I mean, honestly, Stephanie, I just want you to make honest effort, right? I'm not trying to have you do more than is reasonable, but what you've done so far is just not reasonable. Give it an honest effort. Show me that you're trying, and I'll meet you halfway. Okay. But so far, you're not showing me that you're trying. So if we're on May 26th having the same conversation, bring a toothbrush. All right. All right. And this brings us up to, well, can I ask, okay, well, our next case would be People v. James Herrera. Let's go ahead and do that. It's file 25-7090FH. Counsel, you want to state your appearances, please?
Mr. Goodrich, Plain County Prosecutor.
And James Gilbert here on behalf of Mr. Herrera.
All right, and this is the sentencing on a charge of operating while intoxicated, third offense, 5-year maximum, and a DWLS 93 days, 0 to 6 guideline range. Have you had a chance to review the report and recommendations with your client?
We have, Your Honor. We have no additions or corrections.
All right, and any scoring challenges?
No scoring challenges.
Ms. Goodrich, any additions, corrections, or scoring challenges?
No, Your Honor.
All right, we also, I think, we did a show cause as well, that we were told that there was a problem with Mr. Herrera's sober limit. Anything you want to report to me about that, Mr. Gilbert?
Your Honor, when I learned about that, it seemed like there was a logistics problem about trying to recalibrate it because my client's from downstate. I did have him get all his receipts that he's been paying for the sober link. He's been blowing in the sober link. There's been no things that have come back positive. It seemed like the person that services it wanted him to come up to Sheboygan, and he said he couldn't do it right then because of the logistics. And however, there has been, like I said, he's gathered all his receipts, and since Friday, he's been making sure he takes pictures to show the court that he's not violating any order.
Do you know what it means in the affidavit to say that he wasn't cooperating and is out of tests? Do you know what in the world that means? How can you be out of tests on a sober link?
I wonder what that meant as well, but that was the communication from your office and their discussions with the defendant about the sober link.
Okay, I just don't know what that means.
Right. I don't know without it being downloaded, whether he was maxed out that they couldn't download any further information would be my guess. Because he wasn't coming up to download the information.
Well, all right, well, we're here for sentencing. I don't really still know what that means. And if the prosecutor doesn't have any further information about what that means, I'm gonna go ahead and dismiss the show.
Thank you very much, Your Honor.
All right. And Ms. Goodrich, you said you had no objections to the scoring as well?
No objection to
Okay.
scoring.
Go ahead with any allocution, Mr. Gilbert.
Oh, Your Honor, we're in favor of the recommendation. I know the court was concerned about the priors and with being a third offense. However, I would point out that the last OWI that my client had, it was 19 years ago or 18 years ago. It has been a significant amount of time, and talking with my client, it's an issue that he has addressed. He'd sort of gotten away from it, that his sobriety, and thought he could handle it. And obviously that turned into this conviction. He understands that, and I believe stands before you very remorseful for that, and has implemented the things that he was doing for the 18 years so that he was in control of any type of alcohol consumption. I believe that he has learned in the time period that I've been representing him. I mean, he hasn't had any issues where he's been using. He hasn't tried to cheat on the sober link. He stays active, trying to focus on things around his farm and that type of thing, so that he doesn't drink. He says he's got it under control, like he had for the years before. This was an 18-year slip up. I don't believe you're going to see him out again, and I would ask that the court minimize any type of incarceration. Understand there's got to be an example to the community. However, I don't believe Mr. Herrera is a huge threat any more than anybody else out there to public safety. Again, granted, his history is there, but it is substantially whole. And I would ask the court to take that into consideration. Again, he's been on bond for quite some time and has had no issues. Thank you.
All right, thank you, Mr. Herrera. You don't have to make a statement today, but you're allowed to. Is there anything you want to tell me or not?
Yes, deeply ashamed the actions that's brought me here today. Very ashamed of the burden that this is putting on my wife and will continue to put on my wife. And I fully accept accountability for those actions that brought me here today.
Thank you. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, we are here because on September 13th of 2025, the defendant was found unconscious behind the wheel on South Straits Highway. He had multiple empty cans of White Claw surrounded by him. Law enforcement instructed the defendant to put the vehicle in park. The defendant responded by grabbing his sunglasses on the dashboard. The defendant's zipper was down and his pants were soiled. The lab determined his blood alcohol level was a 0.280 over 3 times the legal limit. He's 58 years old. His first arrest was at 20. He had 0 prior felonies and 7 prior misdemeanors. There is a 16-year gap in his criminal history. He was in jail 1 time, probation 2 times. He's unemployed. He did complete a substance abuse assessment during this case, but I was also surprised to see in the PSI that he was convicted of DWLS in Charlevoix County while on bond for this case. That was missed by us. He does have 5 prior OWI related offenses. His last one was in 2007. He explains this behavior that after 16 years of sobriety, it was broke while he was trying to self-medicate with health issues he was having based on his driving while license suspended conviction and having 5 priors. I don't believe that the 30-day minimum for this offense is appropriate, that it should be 60 days. Thank you.
Mr. Herrera, by my count, this is your true 6th drunk driving conviction. When I look at the history there, in 1988, we had an OUIL in Arizona, got fines and costs. 1989, same thing, Arizona, fines and costs. 1993 in Gratiot County, it was unknown sentence. 1998, your 4th. In Grand Traverse County, you got probation and fines and costs. He had a suspended license charge in 2003, fines and costs. 2007, your 5th drunk driving in Grand Traverse County. You got sobriety court. You did a whopping 21 days in jail for your 5th drunk driving. You successfully completed your sobriety court, and there is a 16-year gap. That's good. I want to tell you, but for that 16-year gap, I would most likely be sending you to prison today. 6 drunk driving convictions. The guidelines don't take into account the fact that this is a 6th conviction for OWI, nor for the pattern of drunk driving, committing the same offense over and over and over and over again. They also don't adequately take into effect that you were convicted of suspended license while this case is pending. What in the world is that about? While you got this case pending, then you're driving on suspended license in Charlevoix. I'm not telling you, 6 drunk drivings, the guidelines don't matter that much. 6 drunk drivings. So if you didn't have that 16-year gap, I promise you, today you'd go to prison. But given the 16-year gap, I think it's reasonable to not send you to prison. So I am going to place you on probation. It's going to be for 3 years. The probationary order can include just the OWI charge if you want, the felony charge. We'll put them on probation. Yeah, it'll have to because it's 3 years. So that'll be subject to the terms and conditions on pages 2 and 3 in the pre-sentence report, including support group meetings and treatment as your field agent recommends. You can't drive without a driver's license. You have to get and keep a job. You have to do 60 days of community service. There's a crime victims assessment of $130, court costs of $350, $93.18 OUIL reimbursement. There's $118 in state costs. You have to comply with DNA testing and pay a $60 fee, and I'm going to assess $500 fine. And then in terms of the jail, I do think that the guidelines don't adequately take those things into account. 6 drunk drivings really calls for a totally different change. It looks like in the past, you haven't gotten a whole lot of jail, and that hasn't done the trick. We're still here on your 6th conviction. So you're going to do 1 year in the Sheboygan County Jail starting today, credit for 3 days previously served. On the DWLS, it'll be 93 days, credit for 3 days previously served. I will approve you for participation in the CBT program, classes in the jail that can shorten your sentence, as well as the jail's trustee program that can shorten your sentence if you're eligible for that. That is a departure from the advisory guidelines. I've set forth my reasons for the same. I think it's proportionate to the seriousness of the circumstances of the offense and offender. If you want, you can petition for early discharge from probation at the halfway point if you've successfully completed its terms. So we're going to hand you a piece of paper explaining that. Also, you can appeal to the Court of Appeals if you wish. If you want a lawyer, you have to ask me within 6 months. We're going to hand you a piece of paper explaining that. Ask you to initial 1 copy for us that we have a record we gave it to you, and the other one is for you to fill out if you want to take an appeal. Within 24 hours of release, you have to contact your supervising agent. Do you have any questions for me, sir?
No, sir.
If you violate probation, I will be sending you to prison.
Okay.
Good luck. All right, and then up next, we've got People v. Tristan Long. It's file 25-6997FH. Counsel, you want to state your appearances, please?
William Balser on behalf of Mr. Long, who stands before me.
What was your last name, sir?
Balser, it's B as in boy, A-L, C as in cat, E-R.
Oh, okay. And have you filed an appearance in this case?
Yes, Your Honor.
Oh, see, you noticed that. Okay. Oh, yeah. Okay. Just a couple, just
Just a couple weeks ago, Your Honor.
okay. All right. We're here for sentencing on a charge of larceny by false pretenses of 5 years statutory maximum and guideline range of 0 to 9 months. If you had a chance to review that report and recommendations with your client,
Yes, Your Honor.
do you have any additions or corrections to the factual information in that report?
No, Your Honor.
And any guidelines scoring challenges?
No, Your Honor.
Mr. Juliet, did you have any additions or corrections to the factual information in the report?
Not the factual.
And I do see that you had filed an objection to OB 19. You want to go ahead and place that objection on the record?
Yes, well, this case was pending, defendant failed to appear at court. Bench warrant was issued to be discharged with absconding on a felony bond. That was what later dismissed as part of the plea agreement in this case. OB 19 is not a broad variable, so conduct in the absconding case is not limited to just that case used in this case. I cited the unpublished case, People v. Kibbe, that shows that failing to appear at court and even failing to answer the PSI interview process can constitute administration of justice. There's other unpublished cases out there that suggest the same. In this case, it was scored at 0. I think it should be scored at 10 for those reasons.
Okay, Mr. Balzer, your response?
Your Honor, I actually I've had the opportunity to discuss with my client the issue of the matter regarding the absconding for the fact that the case had been that there was a nollie process in the matter. I didn't take that into consideration in the conversation in relation to the PSI.
Well, I mean, the people that filed a, what do you mean? What do you want me to do with that statement?
Your Honor, I believe that the scoring that's in the PSIR is correct as it stands. I would ask that the court would follow the PSIR as it stands with the original numbers.
Okay, thank you. Well, in People v. Mitchell is an unpublished Court of Appeals decision in 2022, docket 359563. That was where the defendant failed to appear at a sentencing hearing, and they supported scoring OV19 at 10 points. People v. Cunningham, 2019, again, leaving the courthouse before the verdict. That scored OV19. People v. Sowers, 315 Mishap at 349/2016. The Court of Appeals said that OB 19 is generally scored for conduct that constitutes an attempt to avoid being caught and held accountable for the sentencing offense. There's the judicial process is obviously part of the administration of justice, and there's both published and unpublished case law that supports the prosecutor's contention that failing to appear for court while a felony case is pending does interfere, or at least attempt to interfere with that administration of justice. So therefore, I sustain that objection and would score OB 19 at 10 points. That would bring the OB level to 15. OB level would be 2, is that right, Ms. Juliet? And would that be 0 to 11 months?
Right.
Okay, 0 to 11 months. All right. All right, Mr. Balls, or anything you want to say on your client's behalf?
Yes, Your Honor. Excuse me. So while obviously we had discussed that my appearance is only from a couple weeks ago, I've had numerous opportunities to have discussions in the matter with Mr. Long. And while the events that bring us here today, they happened back in October of 2024, I truly believe that there's been a lot that's happened in the positive in Mr. Long's life, both from the beginning of the case and what brought him to then the PSI report being prepared, and then from the report to today. At the time of the report, Mr. Long was not employed, and he is now. He's gainfully employed. He is the primary provider in his household. He has a newborn son that is almost 2 months old. He also is the father of 3 other children he pays child support for as well. Mr. Long's position is that he takes responsibility for what he has already pled to, and in the expectation of the sentencing today. The sentence report as it stood showed a 0 to 9 months, and at that time I had calculated that it would have been 242 days with the 32 days of jail credit. I don't know what that would be with an additional, I guess, roughly 60 days. Your Honor, excuse me, Your Honor, I think that Mr. Long being out and being able to provide and continue working so that he can pay the restitution that he owes is absolutely, I mean, it's paramount. And I know that Mackenzie, his partner and fiance, she just recently having given birth, she's in what people call the 4th trimester. That's in her postpartum. I believe it's necessary for Mr. Long to be able to provide for her, provide for his children, and as well, Mr. Long's also been regularly investing his time in the community. He is actively involved at a rec center where he volunteers his time with the local children of his community every Monday and Wednesday. I believe that just as in the totality of circumstances situation, everything that Mr. Long has done to address to become a better member of the community, he hasn't been involved in any other type of illegal activity since what's been included in the PSIR. All of that should be taken into consideration. Mr. Long would ask that this court would consider a period of probation that would allow him to pay for that restitution. We have someone that's either here or on the way that has a substantial portion of what's owed, so that Mr. Long can make a good faith effort in showing that he intends on making good on what is owed. He also has prepared a letter that he would like to address both the court and the victim today. I would ask just one last thing, Your Honor, if the court is not persuaded and would like or would choose to include some type of jail time of any type, that it would be held in abeyance just to allow Mr. Long to successfully complete that probation and to make those positive steps towards paying that that restitution. And if it would please the court, if Mr. Long could address with the letter that you provided.
Great, thank you. Mr. Long, you don't have to make a statement today, but you're welcome to. Is there anything you want to say?
Yes, Your Honor.
Go ahead.
I wrote this letter to express my sincere apology to the court and to Angelica regarding my actions that led to this situation, and take full responsibility for what has happened. And I want the court and Angelica to know how truly sorry I am for the position I have put everyone in. I regret my decisions and the impact they have had on everyone involved. Angelica did receive the house that was part of our agreement, and I'm sorry for any stress, confusion, or hardship my actions created for her. I never intended for things to reach this point, and I take accountability for allowing it to happen. I understand the seriousness of this charge and the consequences that come with it. This experience has made me reflect deeply on my actions, and I am committed to making better decisions moving forward. I respectfully ask the court to consider my concurrent circumstances. I am the primary provider for my household and a father, and my family depends on me every day. The thought of not being there for them weighs on me heavily. In addition, I want to make things right by paying restitution to Angelica, and I know I cannot do that incarcerated. I'm asking for the opportunity to remain in the community under the court's supervision so I can continue working, support my family, and fulfill any financial obligations ordered. I'm fully willing to comply on any conditions the court sets, including probation, payments, plans, or any other requirements. Again, I'm truly sorry for my actions and the impact they have had. I respectfully ask for leniency and the chance to prove through my actions that I can be responsible, accountable, and make this right. Thank you. And I do have $5,500 to pay today.
Okay. All right, thank you, Mr. Long. Mr. Juliet, any recommendations from the people?
Well, first, Your Honor, did the court receive the victim impact statements?
Yes. Yes, I did.
Your Honor, the recommendations for 9 months in jail with no probation, I think that's entirely appropriate. Looking at the criminal history here, and nearly all of his convictions are theft related. He's sort of what I would consider a serial thief. I guess what's more important to me is the fact that Ms. Goddard, when this was going on, clearly didn't have the money, and he took advantage of her. So he's got several prior theft-related crimes, some of them put down from felonies to get misdemeanor convictions. I think the recommendation is appropriate, and ask for it to follow it.
Thank you. Well, Mr. Long, you're 29 years of age. You've got a prior felony, 7 prior misdemeanors. The thing that does trouble me is kind of what the prosecutor alluded to. When I look at your history, in 2013, you've got home invasion. So that's your felony. You were given a chance for a HIDA and that got revoked. Looks like because while you're on the HIDA, you committed embezzlement. Well, it was a larceny in a building, pled down to a misdemeanor embezzlement. So while you're on a HIDA for a home invasion, you're stealing. So you got an assault, a DWLS, then another receiving, concealing stolen property, pled to a misdemeanor from a felony. Some more traffic, disorderly. Then this false pretenses felony here, and you've also got a defrauding an innkeep. So, I mean, your main problem seems to be that you're just not an honest person, Mr. Long. I mean, you've been convicted several times for theft and fraud. You got any explanation for that?
Oh, Your Honor, I just take accountability.
You know how many convictions most people get their life for fraud and stealing?
No, sir.
None. It's not that hard to avoid being convicted for stealing and defrauding. You know how you do it? Don't steal. Don't defraud. Be an honest man. You've not done that so far. So given that history of theft and fraud crimes is certainly reasonable grounds for incarceration despite the intermediate sanction scoring. And in fact, the recommendation at 9 months was at the top end. I mean, I think top end's appropriate. And now the top end's 11. So you're doing 11 months in the Sheboygan County Jail. Credit for 32 days previously served. There's $68 in state cost, $130 in a crime victims assessment, $350 in court costs, $6,825 in restitution. I am expecting that $5,500. Were you lying to me about that, or is that true?
No.
That's true. So I'm going to see tomorrow that $5,500 is posted on this.
Yeah. Well, I might have to provide for my family too, and if I'm not out, I can't do that.
So now you're not going to post the
No,
55.
I'm gonna, but I'm just gonna, I might lose my house and a lot of things.
All right.
I know I will. She'll take care of that, but
I believe you're lying to me. So we'll see if that actually happens.
Yeah, she will post it.
All right. And I will approve you while you're in the jail to participate in the CBT class. That could maybe help you address some of your thinking that gets you in these problems. I will also approve you for the jail trustee program. If they determine that you're eligible, you can shorten your sentence a good bit through that. You can file an appeal to the Court of Appeals if you wish to challenge my conviction or your conviction or my sentence or both. If you want a lawyer, you have to ask within 6 months. We're going to show you a copy or give you a copy of those appeal rights right now. Ask you to initial one copy for us. The other one is for you to fill out if you want to take an appeal. And I do expect you to see good efforts to get that restitution paid down, or we'll do show causes for contempt, and you can do 93 more days, one after the other, as long as it doesn't get paid. Okay. All right. Good luck to you.
Your Honor, there's just one more thing. We just briefly spoke. I'm from downstate, so I know I've heard about your weather conditions, but I'm not super familiar. And Mr. Long had mentioned that he's trying to essentially, from my understanding, weatherize his house with whatever's been going on with flooding. Is it possible that Mr. Long could prepare his house and whatever he's addressing there, and then?
No, it's my regular practice that on sentencing day people serve their sentence, and he knew that the day was sentencing day. Yeah, you're going right now.
Thank you, Your Honor.
All right, thank you.
All right, court is calling 2025 CR 008182 State versus Jay Taylor. Can I have parties announced?
Megan Galloway for the state.
Ferguson for defense.
And are you Mr. Taylor?
Yes, ma'am. How you doing?
Doing great. How are you doing?
Doing good.
All right. Did you review the motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision with your attorney, and did you understand it?
Yes, ma'am.
All right. Are you the same J. David Taylor who was placed on deferred adjudication in 2025 CR 008182 for the offense of robbery on August 18th, 2025 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant J. David Taylor did then and there fail to report supervision officer as directed for the months of November and December 2025 in violation of condition number 4.
How do you plead to that? True or not true?
This would be true.
And violation of condition number 4 in Bear County, Texas, the defendant J. David Taylor did then and there fail to report to the supervision officer as directed for the months of January, February, and March 2026 in violation of condition number 4.
How do you plead to that? True or not true?
This is true as well.
All right. Did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in the prison and up to $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes.
Court will find 4 and 4 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking that you grant the state's motion and enter an adjudication of guilt against the defendant, revoke his community supervision and supervision.
All right. And defense, what are you requesting?
We're requesting that the court follow the probation's recommendation, which is to continue him with bi-weekly reporting. It also references a mental health evaluation that was scheduled for May the 4th of 2026. Now, in conferring with my client, he has said that he doesn't see the need for that mental evaluation. As mentioned in the recommendation from probation, it says that when he was reporting, it had mentioned some mental health issues, and that's why that was scheduled. At this current time, he is saying that he has, let me back up. Bottom line is he's saying when he was in jail for about 4.5 months prior to this offense, prior to being placed on deferred adjudication. When he was released, he had lost everything, his apartment. And one of the main things that happened was that he had all of his identifying documents were gone.
So here's
And he can speak.
the big question is, why didn't he report? He's been missing since 2025. So that's the number one question.
And what I would say, Your Honor, is that I've advised him of the issues involved with you testifying at this proceeding, but would you like to further expound for the court why it is you were not reporting? Remember, this is what we've been talking about the whole time, that's what the court's gonna wanna know. Yes.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
J. David Taylor.
All right, why were you not reporting?
Basically, when I got out of jail, I basically lost everything. I went through an eviction. I lost the car, my phone. They basically just threw all my stuff away, my documents, school transcripts, everything I had worked for. And then I basically missed the first probation, like by 3 or 4 days. So I figured they had a warrant out. So I just wanted to kind of show up to probation with a payment because I had went the first 2 or 3 months and they were requesting like $80.
All right, everyone whisper. We're on the record. I cannot hear. All right, you may continue.
I wanted to at least go to probation with a payment. It was kind of unusual not having employment, but due to not having my documents, I wasn't able to secure a job. So I know it doesn't allow a lack of accountability, but now that I do have some of my documents retrieved, like my birth certificate, I got my social, and I'm working with KRL and Corazon Ministries, and hopefully Haven for Hope will accept me, so I'll have like a place to stay. It shouldn't be a problem in the future.
All right.
And so, Your Honor, we would ask the court to consider continuing him. He also has job prospects. He actually has a job, understanding with factory. And so he had issues, but we think that if the court were to continue him, that it would not be an issue moving forward, Judge. If the court is not inclined to continue him, we would ask the court to consider the minimum.
Well, no. Any questions?
I do. Okay, and so at the time that you were placed on probation, the address that you provided was that you were living at 1 Haven for Hope Way. Is that where you were living at the time?
I was at Haven for Hope. That was the last address, but this would be like 8716 Fairhaven. That was the last address was.
So hold on. So before you went into jail, you were living at Haven for Hope?
No, I was living at Fairhaven.
At Fairhaven, and then when you were released from jail, where did you go? To Haven for Hope?
Well, I was evicted, or I didn't have that apartment anymore on Fairhaven, so I went to Haven for Hope, and they said I needed a referral to get back in since the last time I wasn't there for more than 30 days.
Okay, and then you reported to probation that you were unemployed.
Right.
Okay, so why did you report that if you had a job?
I didn't have a job at the time that I was out of jail. I was in there for 4.5 months, so I didn't have employment at the time or my documents or anything.
So are you saying prior to being in custody at the jail, you had a job?
I would say I was working at the time, right? I worked down on Grayson.
Oh, okay. Okay, and then you're saying you lost that job as a
Right,
result
yeah,
of being
and being
custody.
in jail for 4 months, they said I was like, no call, no show, so they terminated me.
And then I guess just as a result of you losing your identifying documents and stuff, that's not something that you have to show to probation to report, correct?
Right,
Right, so how did that have an effect on you not?
I would say, the first 2 months that showed up, they were requesting $80. I was, always used to, providing and paying rent, so. Not having, a job and then trying to reapply was difficult due to the fact that I didn't have a social birth certificate or anything. They basically just threw all of my stuff away.
Okay. And then I guess you also said that you were scared because you were a couple of days late and you didn't.
Right,
you
the
didn't
last
well.
probation date, I think around December, whenever I guess prior call to verify the date, I still kind of missed the date by like 3 days or so, so I figured they had a warrant. And I just wanted to kind of gather my documents, et cetera, and at least bring the payment.
Okay,
But
all right, thank you. No further questions.
All right. Court will hear argument.
Judge, we're just asking for you to grant the state's motion and submit him to 6 years in prison.
Your Honor, we would ask the court to consider probation's recommendations. They know this client. They know his demeanor. They know what he has been doing. One thing that was not mentioned, he was homeless at the time, living under the bridge. Is that correct? Right. So there were some significant transportation issues. But we would ask the court to consider probation's recommendation of having him to report bi-weekly. He understands that if he were to violate again, that he is still facing a full range of punishment. If the court is not inclined to continue him on his probation, we would ask the court to consider the minimum here, which will be 2 years based on the actual offense, which he has yet to be adjudicated for, but that he did plead guilty to, or no contest.
All right. I never understand how someone, if you didn't report for all this time, I don't understand how, okay, we're going to make them report double means, helps with anything. I don't see that as being rehabilitation. All right, this is what the court is going to do. The court is going to grant the state's motion, revoke, find you guilty. There's to be no contact with Erica Aguilar, no contact with the Dollar General. The court will request the therapeutic community, and the court will sentence you to 4 years in the prison, give you credit for any time served. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney, and I'll retain jurisdiction. All right, thank you. All right, Mr. Robinson. Court is calling 2025 CR 012572-02 State versus Carl Robinson. Could I have parties announced for the record?
State.
Michael DeLeon for Mr. Carl Robinson.
And are you Mr. Robinson?
I am.
All right, so I did find you guilty. And I took an extra day just to consider whether or not I would grant your application. And I will tell you, there's a lot of things for a judge to weigh when they're considering whether or not to grant someone community supervision. Like sometimes people will say, well, you gave that person deferred. Why can't I have deferred? It's the same thing. But I try to stress to people that each case is individual, right? And there are certain facts in certain cases. Like, for example, I know part of the argument is like, well, the co-defendant got deferred adjudication. And I understand that potentially this never would have happened if she hadn't agreed to meet up with somebody, pretend that she's going to be intimate with them, and then they're being set up to be robbed. And I know that person doesn't come with clean hands either, meeting some stranger at a hotel room. But in your case, the facts are that you went there and you went there with the intention to rob. This isn't something, according to the stipulations that I've read, this isn't something where you just happen to be there. You're upset that your girlfriend is agreeing to be intimate with this person. This was all set up for a robbery. And then in the stipulations, the guy says that you were trying to test whether or not his gold chain was actually gold or test the weight of it. So those are problems that I have. And I do realize that you're young. I do realize that the state proceeded on this case as a robbery. So this is what the court is going to do. The court, as previously stated, is finding you guilty. The court will sentence you to 4 years in the prison. The court will retain jurisdiction. Court will give you credit for any time served. And the court will request the therapeutic community. Is there anything else with regards to sentencing?
Nothing, Your Honor.
All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so I've retained jurisdiction. Your attorney knows what that means, but if you're coming back to me, you're gonna have to show me something, and he'll inform you what I mean by that. All right, thank you.
Thank you, Judge.
All right, who's next? What page was he on?
Page 9.
Thank you. Eddie Baldwin? Oh, he's here?
Yes.
Okay, I was just checking to see if he made in.
He was.
Yes. All right, and Mr. Reyes? Isaias Reyes? All right, you need to be on the second row.
Second row. The other row. Bring it.
All right, good morning. We're gonna go on the record in Knowles versus Knowles. It is Nicholas Knowles versus Amber Knowles. 2026 DM 62 Butler County District Court. The petitioner appears at the office of Tina Huntington. They appear by Zoom. Separately appearing by Zoom is the respondent with her newly entered attorney, Whitney Chrisman. This is a status or a proper hearing, if you will, on a motion to modify temporary orders. This case was filed originally as a pro se filing on February the 19th of 2026. And so 60 days has elapsed since the filing of it. Then there was an entry of appearance on behalf of the petitioner by Ms. Thomas. Then with the DRA being filed. And then there was a child support worksheet, and then an answer while Amber Knowles had counsel who has now withdrawn. And that was Julian Thomas with a proposed worksheet. I signed a temporary parenting plan on March 12th of 26. There appears to only be one child, RK, who's 2 years old, of this relationship. Oftentimes when pro se divorces are filed, there are no temporary orders. And that is because forms are provided that people can look at and try to use by OJA and legal aid, and nobody though seems to add temporary orders. And of course, with not having counsel, usually, frankly, they aren't entered in pro se filings, but there's also a temporary order that the court signed on March the 12th as well. And then a motion to modify has been filed by the petitioner. So I must have signed. I mean, I guess I take the view that if there are no temporary orders, that any party's still allowed to ask for an ex parte temporary order. It's unusual when there's two attorneys, but I don't know that there's anything that prohibits interlocutory orders by either party if none exist for the interim until finalization of a divorce. But at any rate, obviously, Ms. Huntington, you are not satisfied with the temporary orders, and you've requested the court to review those orders, which typically speaking, you're entitled to a 14-day or 21-day hearing on those matters. And you haven't had your opportunity because counsel withdrew and now there's new counsel. But I do want to review these temporary orders this morning to see if there's anything that I'm inclined to modify. Ms. Huntington, I will tell you this. We've had quite a few cases together most recently in the last year and a half, I think. But my position typically on temporary maintenance or spousal support, even if it's not a long-term relationship, is generally people don't get long-term support. But I believe that during the pendency of a divorce where everyone is relocating or readjusting their finances or whatever they need to do when there is a divorce, that even if it's short term, it's transitional. So although the court may not award spousal support or maintenance or assistance as a final decree for any kind of significant term, often it is something that I do award on a short-term basis if a party can show a need. But I'm going to let you argue your motion real quick. I'm going to let Ms. Chrisman respond, and we'll kind of see where we're at and how far apart you two are, and how close you might be in resolving a lot of these matters to just formalize the divorce itself.
Judge, I apologize. I hear that you're instructing petitioner to proceed on her motion. I had emailed the court yesterday. Basically, I didn't file an entry of appearance until yesterday. I was not provided any exhibits from the petitioner. I was just retained Friday afternoon. And so I was requesting like a week or two of a continuance. I understand there is an objection. I completely understand that. I understand that the petitioner has a right to be heard over a motion to modify an ex parte orders. I'm not prepared to proceed. I haven't seen any documentation or anything about the support issues or anything like that. But I would ask the court to consider just a week or two for me to be able to become familiar with the case. I don't want to belabor it by any means.
Right. I'm sorry, but I feel like when an attorney enters and knows there's an impending hearing, they have to make their decision of whether or not they're going to represent based on can they appear and represent the client at the impending hearing and not assume that there's going to be a continuance because there's a recent entry of appearance. I try to do that. I typically do that, but not in cases where it's on a motion to modify an ex parte order that they haven't been heard statutorily as they're entitled to or otherwise. And these were granted without an involvement of an attorney, and I think I need to review them. So that doesn't mean that I won't give you an evidentiary hearing on the temporary orders again if you want a full evidentiary hearing before finalization. But I want to review these temporary orders with both counsel and both parties here briefly this morning.
Certainly, I would just make a blanket objection to reference to any documents I haven't been provided by counsel.
Okay. All right, Ms. Huntington.
Thank you, Judge. Hearing what the judge has said with regard to an evidentiary hearing, the main concern for my client today is getting parenting time resolved. In November, I don't know the exact date, that's when the parties separated. December. My client was having parenting time essentially every Tuesday or Thursday, and then every other weekend. And that continued up until March when this temporary order was filed. The temporary order, Judge, has my client only receiving a few hours one night a week on Tuesdays. That's not consistent with the de facto parenting plan that the parties have followed for months now. It's not in the best interest of the child to only see her father once a week for a couple of hours. Child's 2 years old, as the court pointed out at the outset of this hearing. Having frequent contact with both parents is important during, for a child of that age. I know that the respondent will say, well, the petitioner assaulted me. And there is a case involving that, Judge, and I've watched the video and I know I'm not the decision maker, the court is. But what occurred was my client appeared for a child exchange and the respondent tried to climb in his car and take things out of the vehicle. And he tried to pull her out of the car, which led to her calling the police and filing a battery case against him. There is a ring video that shows the incident. I think he's got a first appearance on at least part of that tomorrow. May 11th.
What court is that in?
It's in Butler County.
Is it the district court or a municipal court?
I believe it's district, ma'am.
Judge, you did the first appearance on the first case, but there is a second case.
The second case relates to now allegations of violations of the temporary order. My client believes he may have contacted her over social media. He's very distraught over the divorce in general. And so that may have occurred. But there's no attempts to contact her or come to her house and assault her. There's nothing like that, Judge.
Okay. Ms. Chrisman, what do you believe, based on discussions with your client, is going to be her position as to why he poses a danger or threat to the the minor child of the parties?
Yes, Judge. So first off, we're unaware of any overnight parenting time that he's exercised, so we obviously disagree with the de facto. We don't know what his home looks like. We do know that he has made some pretty aggressive suicidal statements. We obviously don't want a 2-year-old to be subjected to anything of that nature. With any DV case, he's going to be prohibited, at least during the pendency, from having any firearms. There are a significant amount of firearms. The incident described, yes, there is a video of him dragging her out of her Tahoe that she has possession of at this time. There was also a severe DV incident in Christmas of 2024. There was a severe incident where my client thought that he was going to kill her, January 25th of 2025. The child was present for that. And then there was also the final incident that's alleged in the criminal cases, as well as continued violations of the protective order that's been in place by law enforcement. My client is concerned with all of these items. And there are oftentimes when domestic violence, when he no longer has his primary victim, it shifts to the child, especially a female child. And so we do have concerns, one, that he's not exercising his actual parenting time. It's grandma. He hasn't had overnight time. We disagree with what the de facto is, but also the suicidal ideations that could occur in front of the child, as well as the firearms as well.
All right, what else is at issue?
Well, the other would be the spousal maintenance, Judge, and then my client's access to personal property at the marital residence. He's been unable to obtain those. I had requested in the motion that he, with the police assistance, that he be able to go there and retrieve personal items, clothing.
I have clothing, it's just all my others.
Yeah, there's a lot of small items, and we could do an inventory and provide that. I do want to say on the criminal case, we've noticed a pattern, and it's a pattern to us. Maybe it's coincidental, but after we filed the motion to modify, there have been no contact between the parties, and the respondent called the police, had the police come out and talk to my client. After we turned over the exhibits last week, she called the police again and had them come out and talk to my client about an alleged incident in November. Judge, this is just escalating into an attempt to prevent my client from having parenting time with the child. I don't know. My client tells me they were doing overnights. That was the de facto schedule. I'm not sure how we can prove that, but maybe my client's mother can come and talk about that. But he does not pose a risk to the child. He has struggled with the divorce, as I mentioned before. He doesn't want it. This is not the path that he wanted, but restricting his access to his child is just adding more just more stress to him, and with how he's dealing with the whole situation, Judge.
Okay, so this is the second marriage for your client, correct?
Yes.
All right, and does he have any children from a previous relationship?
Yes, he does, Judge, and I included in our exhibits, just so that if the court wanted to look at that, he has a parenting agreement with those children. They come to see him in the summer. That they live out of state, so there's some long distance travel there.
Okay, and then this is a third marriage for your client, Ms. Chrisman. She has 2 children from a previous relationship, is that correct?
That's correct, Judge, and she's the primary custodian for those children.
Okay. And where is your client actually living, Miss Huntington?
South Ohio.
He's in a house of his own now, 227? 127 South Ohio.
Is that in Benton?
Yes.
Yes.
Okay. And then she's out east of town of El Dorado. And was that a marital residence there?
Yes.
And does that have property with it? Do they own it?
No, well, it's a rent to own situation.
Okay,
And that's the same for my client in his new residence.
okay.
Judge, I believe the home is just in my client's name, and that predated the marriage as well.
Okay. And is your only, let's see, how much was awarded as maintenance?
It was 900.
900, Judge.
And then what about child support?
That was 1,001, I believe.
Yes. And with regard to the child support, he does pay $1,155 a month to his other, under a separate order for the other two children. That's not accounted for in that child support worksheet.
Okay. All right, well, Ms. Chrisman, it is fairly uncommon not to give a parent a visitation schedule that includes an overnight. And unless there's some allegation of unfitness to parent and folks are asking for supervised visitation, that's generally the restrictive layer that typically occurs. So I really think that he should at least have one overnight. And so I'm going to I'm not going to go Friday because of the age of the child. I'm not going to start out with Friday to Sunday. But I am going to start from Saturday AM to Sunday PM. And that can be 9, 8, 9, or 10 AM, whatever works best for the parties, given whatever schedules they have and other commitments with other children. And then by 6 o'clock on Sunday. And of course, the child needs to be clean and fed by 6 PM so that the other parent doesn't pick the child up or get the child and immediately have to do all the parental duties. So it should entail making sure that the child is clean, well cared for and fed and dressed appropriately, etc. I am not inclined though to change the maintenance right at this very moment until I can figure out all their financials. And I would assume that predominantly he is much more concerned about having contact with his child than how much he's paying out of his pocket. I can't really help that he's got other children that he's responsible to support, but he does get a credit when overall you're looking at the number of family members or children that he is supporting. And so that worksheet ought to be recomputed just based on the fact that the right family number wasn't used. Usually that doesn't make a tremendous difference, but it may make some. And then I'll go ahead and sign a new worksheet for that. But I'm not going to modify the maintenance at this very moment until I can fully review the evidence. And I am happy to set the temporary order for a full evidentiary hearing on the parenting time and the financials, or get this case scheduled for trial in the next 60 days on the matters. I can't decide right at the moment whether or not this is a case for domestic conciliation. I doubt it's one for mediation, the way I'm hearing how things are going, but maybe domestic conciliation. So I'll leave that for you to consider. But I'm happy to give you a 60, 90-day trial date. And if you're not ready for trial, you want to convert that into a more substantive hearing on matters that are covered under temporary orders, we could do that as well. Ms. Chrisman, I know that you are at a disadvantage. I mean, you've done an excellent job advocating for your client today. And, you know, I think most attorneys explain to their clients that every other weekend or one day a week is pretty limited restrictive visitation that's not common. And so I think they also will need to go to a parenting app if there's any pending cases or police involvement as well. Either Close App or our Family Wizard, whichever you prefer. But I do want to add one overnight, and that's just every other week. That's just twice a month right now. So I don't think they've gotten anything very, you know, significant in the way of an alteration of what's been part of the temporary orders. But I do think there needs to be at least a little bit of a modification to that. Yes.
Apologies, Judge. My client had downloaded our Family Wizard if petitioner is open to it. I don't know that we can modify the criminal protective order, but I do believe he has a hearing on the 11th, and maybe if we're ready on that, we can get that rolling.
Yeah, I mean, I can approach his attorney in that case and see if we can get some sort of a modification to the protective order so that they can have that communication regarding the child only. I do know that the intention is to set that matter for trial because my client adamantly, you know, denies that he should be prosecuted. So I don't know what's going to come about on May 11th.
Okay. I do want your client, though, since he admittedly is struggling with this divorce, I do want him to get a mental health assessment and find somebody that he can work with in some individual therapy. I think would be helpful to him while he works through all of this. I think that's important that there be an independent party that can notify law enforcement or the authorities if there's any belief that he is a danger to himself or others, which they certainly have a legal obligation to do, even if they're your therapist. So I do want to add that component as well as part of getting this overnight, that I am going to give them a little bit of time before it starts so that he can get an appointment with the therapist and either have seen a therapist or be seeing a therapist right around the time that the overnights begin. So we're looking at we'll start the overnight on May 16th. That gives him plenty of time to see a therapist. The reason I don't want to do the 9th is that's Mother's Day weekend anyway. So let's start on the 16th. And that gives him plenty of time to get an assessment and find a therapist. Okay? And then I'm gonna modify the worksheet, which should result in some decrease in, his child support obligation. And then we can revisit the maintenance, if we're not ready for finalization in 60 days, okay? All right, so let's get a hearing date, April, May, June.
Judge, could I also ask one additional thing?
Yes.
Generally speaking, under the temporary orders, I'm not sure in Butler County, but in Sedgwick County, the parties have to agree if either one of them is going to travel out of state with the child, and that's not occurring. And my client would like to have some say on whether baby girl is going out of state.
Okay, so this is another approach I have philosophically. Now, when people are together, they have a child or begin a relationship or a marriage, bringing to the table what they bring to the table. And it's foreseeable for both parties to know that whatever it is they were doing before they got married and whatever they did during the marriage is going to probably be done after the marriage. And so if the travel is for family that was fair, I don't know what the travel's for. So you need to tell me if she's got a new boyfriend and she's traveling out of state, then yes, maybe that needs to be curtailed. But if she's traveling out of state because her kids are involved in softball tournaments, or there's a grandparent somewhere, or she likes to go to concerts or games or whatever, and it's something that she's done before and during the relationship, I'm probably not going to curtail that activity on her time, unless you can show me she's a flight risk with the child. But at any rate, what is this travel that you're concerned about, and what is it for, Ms. Chrisman? Do you know?
I do, Judge. My plan, or not my plan, my client was planning to go to Omaha with her child for her birthday to go to the zoo, but she's no longer planning to go.
Okay. Well, that would have been a fun trip. When is the child's birthday? I don't know if I have that here.
It's on Thursday.
Oh, okay.
And Judge,
Let's not be petty about things like that.
Well, Judge, I think my client feels like he was an active participant in making decisions, and now he's just been completely taken out of that. It's as though he's not an equal parent. I know there's joint legal custody, but that's not how things have been going.
Okay.
I do think that there are maybe significant others already coming around the child.
Okay, well, that just sometimes adds fuel to the fire. We don't do this in Butler County like Sedgwick County does, but I have seen pretty common orders from Sedgwick County where the judge asks that you not introduce the child to love interests for at least 6 months after separation. So the child can get adjusted to the fact parents aren't together. Parents are living somewhere else. Their schedules change. And just not have one more thing the child's got to adjust to and try to understand. And I'm kind of an advocate for that, especially in marital situations, and especially before people are actually divorced. So I would caution you to focus on your children. And it's hard, though, to communicate when there's no contact orders. So I'm hopeful that there can be a provision made for a parenting app. And I mean, I would be in favor of that because it's monitored. And And that the parents would start communicating a little better through that app than probably what they've been doing since the separation. But yeah, I mean, they've been through this before. When you get divorced, you just have less involvement with your children, and there's a tendency for each parent to go about their plans in their lives, and there's not the same level of communication and agreement on things. But at any rate, I would ask that if she's going out of state, she simply give 48 hours notice that she is on her time taking the child somewhere out of state. And I guess that gives you time to come in and seek emergency order if you think it wouldn't violate the law. But if it is something that is serious enough that it should involve an emergency hearing or motion. Okay? All right. And I assume that the grandma or or someone, or you can mail a gift and a present to the child for the child's birthday. And that shouldn't be a problem. Ms. Chrisman, do you know why either mailing something, having it delivered for the child, or grandma delivering it is problematic?
No, and I believe that grandma's been very involved with exchanges and things of that nature, and so I think that that would be fine.
Okay, very good. Well, she may be an important person to hear from down the road. But if you could also provide a list of property that he wants as part of the divorce that she has no interest in, or again, I go back to what is something the party used and sort of possessed as their own, what makes sense that is theirs, those kinds of things. Yes, there needs to be a value put on them, but there shouldn't be an argument about a lot of those personal items and who they should go to based on prior history of use and that kind of thing. So try to get that accomplished in the next 14 days if you can as well. And then I could do a half-day trial or an all-day trial if you think you'd be ready the week of June 22nd through the 26th. I am open that week.
I have a 2-day trial on the 24th and the 25th, but if we could avoid that, I can squeeze something in.
Okay.
I have trial on the 22nd and 23rd, but I could do Friday, the 26th for half a day.
Okay. Let's plan on that. Do you want morning or afternoon?
Yeah, morning would be better for us, Judge.
Okay. Just keep me posted. We can always pull that and reset that as a final trial. We can use that as whatever we need to use it for. I don't know though, unless you contact me, that we need to do a status before then. So. All right, I'm just gonna put a half-day reserve for them there. If you do decide that you're gonna use that as a full trial day, then we need to do probably a pre-trial conference or an order by the 15th. Actually, that's not 14 days. If you'd waive the 14 days, we could do it on Monday, the 15th at 4.
Should be fine, Judge.
Okay.
I failed to do this in my last trial with you, Judge, so can I request that we have a deadline for the exchange of exhibits?
Yes. Amy, what's that new directive? Is that 14 days out from trial where it is? And just, I'm gonna ask that you submit to me on the 12th. So that's 14 days. It's not business days. It's 14 days prior to the trial. So on the 12th by 5, exchange, then that Monday, we'll have a pretrial conference. So you can be exchanging that information as you're working up a pretrial conference order, because you got to identify it in your pretrial conference order anyway. And so it can kind of be happening simultaneously. And then we can touch base at 4:00 that day, and then be ready for our trial on the 26th.
Judge, do you hold your,
I'm just gonna take that whole day. I'm gonna knock that whole day out for trial.
do you hold your pretrial conferences in person?
No, that's by Zoom, but I do the trials in person.
Certainly.
Okay, anything else today? Ms. Huntington, I would ask that you journalize this hearing, please.
I will, Judge. I don't think we have anything else today.
All right. All right, if there's nothing further today, we are adjourned. Thank you.
Sorry, I'm so sorry, Judge. I had one clarification.
Absolutely.
Does he need to provide proof of completing the mental health assessment and engaging with a therapist prior to the initiation of parenting time, or does the parenting time start the 16th?
I would hope that he could show either completed appointment or when his appointment is before then, yes.
Okay, thank
And
you.
I'd prefer that he be able to see someone. But it depends on the availability of someone and how fast their turnaround is.
Understood. Thank you.
Okay, thank you. All right, we are adjourned. Thank you.
We will go on the record in the matter 23 CF 186 and 187, State of Wisconsin versus Bronson Fisher. The state appears through Assistant District Attorney Jose Vila in person. We have Bronson Fisher in person in custody with his counsel, Emma Hanu. We're set for a plea and sentencing. Ms. Hanu, can you please recite the agreement for the record?
Thank you, Your Honor. In this case, Mr. Fisher would be pleading to count 2 in both 23 CF 186 and 187. And just so the court knows, it's count 2 because in 23 CF 186, the first count is outside of time limits, and rather than have him plead to a count that is outside of time limits, count 2 for both, for simplicity of the court. For a withheld sentence in exchange for 5 years of probation, 140 days, 5 days of conditional jail for time served. A stipulation to the amount in arrears and a condition of probation would include restoring payments to child support and getting set up with that upon release. In addition, the state would agree to uncharged, dismiss and read-in count any uncharged failure to support accounts from the time of initial charging to today.
So count 1 in 23 CF 186 is dismissed outright.
Yes, it appears to be that way, Your Honor.
Granted to dismiss count 1 outright in 23 CF 186. Mr. Fisher, before I begin, are you still on Kruger Road A?
No, that's my old address.
Do you have an updated address?
Yes, I actually got one registered finally just while I was in here to the property that I'm staying in Minnesota.
And what address is that?
And that's Brook Park, Minnesota.
Brook Park?
Yep.
Do you know the zip code?
I believe it's 55007.
And will you have a telephone number?
Yes, I do.
Is it the 3650?
No,
What is the number?
that's 715-6
We send you text message notifications.
Yes,
Okay, so I have in front of me an electronic version of a plea questionnaire waiver of rights form with attached jury instructions. Do you see that in front of you on your attorney's computer?
yes, I do.
Is that the document she went over with you?
Yes,
Is that your signature on the second page?
yes, it is.
Did she thoroughly go over the document with you, essentially word for word,
Yes, she did.
and you understood everything completely?
Yes, I did.
You were pleading guilty to 2 counts of failing to support. Is that correct?
Yes,
That is count 2 in both cases. You're 44 years old. You have 12 years of schooling. You can read, write, and you understand the English language. No drugs, alcohol, or other medications in the last 24 hours, and no mental illnesses or disorders, correct?
that is correct.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page. Do you understand those rights?
Yes, I do.
Did your attorney thoroughly go over those rights with you?
Yes.
Do you need me to go over those rights with you in any more detail?
No, I don't think that's necessary.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes,
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
yes,
Do you understand you're pleading guilty to felonies? As such, you will no longer be able to use or possess a firearm for life.
yes, I understand.
You'll no longer be able to vote in any election until your civil rights are restored.
Yes,
Do you understand that here the state would have to prove for 2 counts, but we'll go count in 23 CF 186, count 2, the state would have to prove on or between November 1st, 2012 through February 28th, 2013 in Burnett County, Wisconsin, you intentionally failed to provide child support for at least 120 consecutive days where you knew you were legally obligated to pay said support. Do you understand what the state would have to prove?
yes, I do.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years of incarceration or both?
Yes,
Do you understand in 23 CF 187, the state would have to prove as to count 2, failing to support, that on or between January 1st, 2018 and April 30th, 2018 in Burnett County, Wisconsin, you intentionally failed to provide child support for at least 120 consecutive days where you knew you were legally obligated to pay said support. Do you understand what the state would have to prove?
yes, I do.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or no more than 3.5 years of incarceration or both?
Yes,
Do you understand that the agreement between the parties is for 5 years of probation for 145 days of conditional jail as a time served and certain conditions while on probation? Do you understand I don't have to follow that?
yes, I do.
Said differently, I could sentence you all the way up to the maximum possible penalty if I thought it was warranted, and I could do so today.
I understand.
Do you understand I could also sentence you to what's called a withheld sentence or an imposed but stayed sentence?
Yes.
Do you understand the difference? I can
Not
explain it.
super, the imposed and the withheld sentence.
Correct.
I'm not exactly sure what the difference is,
The
but
difference is if I place you on probation and I give you what's called a withheld sentence, it means that the entire time hangs over your head, 3.5 years for one charge and 3.5 years for another charge. And I can, at that time, if you're revoked, sentence you to the maximum penalty for both, either concurrently together or consecutively, one at a time. Do you understand that?
yes,
Imposed and stayed means that the court could say today, I'm going to sentence you to 3.5 years of incarceration for each, but I'm going to have you do it concurrently. And I'm going to stay that. And while you're on probation, you do what you need to do. But if you're revoked, you will not come back to court because I won't need to sentence you. You'll just go sit that 3.5 years. Do you now understand the difference?
yes, I do.
All right. And do you understand that it's my discretion in what I sentence?
Yes,
Do you still wish to proceed and enter a guilty plea?
yes, Your Honor.
Did you go over both of the criminal complaints with your attorney, in particular, those sections called the probable cause sections, where it basically says what happened during those periods of time and why you were charged with these crimes?
Yes,
For the most part, are those facts accurate?
yes, Your Honor.
Are you admitting here today that you in fact are guilty of failing to pay child support at least 2 times where it's been over 120 consecutive days?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Do you have any questions for the court or your attorney before I proceed?
I don't believe I have any questions.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No,
You're doing so freely and intelligently, telling the court that you fully understand what you're doing here today
yes,
and voluntarily.
yes,
Has your attorney represented you competently?
yes,
Has she answered all of your questions?
yep,
Has she looked at these matters thoroughly?
yes, she has.
Has she discussed with you a potential for any legal defenses or a lack of defenses in these cases?
Yes,
Has she discussed with you the evidence and the discovery that she's received in these cases?
yes,
Have you discussed with her your facts as you know them to exist during these periods of time?
yes,
Have you discussed with her your thoughts on whether or not you have any defenses or a lack of defenses?
yes,
Are you satisfied with her services?
yes.
Do you have any questions for the court or for your attorney before I proceed?
I do not.
As to count 2 and 23 CF 186, failing to support a child 120 plus consecutive days, and I felony, how do you wish to plead?
I plead guilty.
As to 23 CF 187, count 2, failing to support a child 120 plus days consecutively, and I felony, how do you wish to plead?
I plead guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of counts 2 in both cases. The remaining, as we stated in 23 CF 186, count 1, that's dismissed outright. The remaining counts in that case will be dismissed and read in. The remaining counts in 23 CF 187 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. I think the joint recommendation here is appropriate. To my knowledge, Mr. Fisher doesn't have any felony convictions prior to today, so he's walking away with his first pair of convictions on a felony matter. I think the sentence needs to accomplish the goal of having a big enough hammer to deter Mr. Fisher from re-engaging in that problematic behavior of not wanting to support his child, specifically deterring him from doing that and generally deterring the public from not paying their court-ordered child support. There is a victim in this case, it's his child, and as a result, she has not received support for a number of years. And I don't have the updated number here, but it's somewhere just south of $30,000 worth of arrears. That's a lot of support that she's missing out. I think 5 years of supervision should be enough of a amount of time to keep him on the straight and narrow to make sure that he continues to support his child. Should he fail to do so, he faces revocation and potentially a prison sentence. With that, I would ask the court to adopt. Thank you.
Thank you. Ms. Hanu?
Thank you, Your Honor. I would agree. I believe that this recommendation is appropriate. If the court remembers Mr. Fisher's first appearance here, he was going to plead guilty to every count, not speak to an attorney. The court did advise him rightfully to get an attorney. Since then, Mr. Fisher has remained steadfast that he does want to take responsibility for this. He's doing that here today by walking away with 2 felony convictions for a period of probation that would require him to start to pay. The court is not overly familiar with Mr. Fisher. He's not a resident of Burnett County. So I'd love to tell you about him. Mr. Fisher is a business owner. He creates art, I believe, and does some carpentry and is a generally good person who does want to take responsibility and is here to do that. And I think by giving Mr. Fisher the opportunity to now get out of jail, he's been sitting here since November to get back to his business, to his home, to start getting on track with child support, does the public and does Mr. Fisher and does the court significantly more good than keeping him in jail or prison. ADA Vila is right. There is a victim in this case. That's Mr. Fisher's child. The goal with failure to pay charges is getting somebody back on track, is getting that support. I think this agreement does just that. I would note that Mr. Fisher does have 165 days of credit. This was for 145 days of conditional jail. As of April 8th, obviously, we had to set this out to a sentencing hearing. But I would ask the court to adopt this recommendation.
All right, thank you. Mr. Fisher, is there anything that you would like to add, you would like the court to be aware of about your situation and about this case?
I really just I know I messed up. I just don't plan on getting in that situation anymore. I just want to try to keep on doing the best I can to abide by the law and pay off the rest of what I have to pay. So.
All right. How old is your child? I'm trying to find it. This didn't
I
originate from here.
actually have two children.
Oh, are we dealing with two separate ones? I know
Yes,
LMS.
186 and 187. There's one for each child.
Okay, and so how old are your children?
My oldest daughter is 21 years old. And my youngest daughter is 15.
All right. All right, Mr. Fisher, this is serious well, first the court has to look at how serious is this matter. Then I have to look at you, your history, what you're telling me about yourself, your employment, your age, your education, those things. And then I have to look at needing to protect the public. This is serious in the fact that we're dealing with two children who have not been supported by you for a significant period of time. And if we look at these cases, at least from 2009 on, however, that 2009 can't be included because it's too old. And so that's why that one was dismissed. But it's been a significant period of time where the children have not been supported by you, and they've needed to be supported by their mothers. And hopefully, at least it may only be the financial aspect where you've fallen short. Hopefully you've been there as a parent and you're there to be there as an emotional support for your children, because your children do need you. Even if they are 15 and 21, they still do need their father. But financially speaking, you did create the children. You have an obligation to support the children. And hopefully this is going to get you on track, and to do that because you could actually go to prison for failing to support. I do think that probation is appropriate. And so what I am going to do is I'm only going to order 4 years of probation. Either you're going to do it or you're not, but I think 4 years is plenty of time to be on probation. I'm going to order 165 days of jail, of conditional jail. That's time served. You have 165 days of credit. So that's what the court is going to order. I'm doing an imposed and stayed prison sentence. Here's why. Because this is seriously important that you support your children, even though one is already age of majority. It didn't mean that she didn't need to be supported and that the mother didn't need that extra financial support in order to raise that child. And so what the court is going to do is, in sentencing, I have to look at other factors too in sentencing, in a length of sentence. I have to look at deterrence, not only specific deterrence to deter you from continuing to fail to support or to pay your arrears that is owed, but also general deterrence. So others, mothers and fathers who are obligated to pay support, know that they have to pay that support, and they will be deterred because they don't want to go to prison as well. I do make mention of my very close friend, Sarah in Michigan, in the Michigan Attorney General's office where I served with her. She is head of child support over there, and she is great at her job. And I'm going to tell you, in cases like this, there wouldn't be any wheeling or dealing. You would have to come up with a lot of cash and you would still go to prison. She has prosecuted actors and professional athletes and all of that, plus average day folks who fail to support. And I'm going to tell you, over there, child support, failing to pay child support is far more serious than I have noticed or seen over here in Wisconsin. So what the court is going to do is, if you are revoked off of your probation, the court is going to order 1.5 years of prison with 2 years of initial confinement, and that is going to be a concurrent sentence for both. You are going to be ordered to pay your monthly child support amount plus the arrearage amount, and you must do so timely every month. You are ordered to have gainful employment, and that means that if you're not cutting it and paying the bills, doing your artistry and all of those other things, you have to get another job to not only, well, first and foremost, to pay the amounts that you are owed to pay monthly, but also to support yourself. The court is going to dismiss, pursuant to the agreement, any uncharged failing to pay support from date of charging here until present, until today's date and time. And so you're going to start anew. The court is going to give you, I'm going to say, I don't know where you are with regards to your child support, et cetera, or where they are in collecting, but I'm going to give you 1 month before you have to start and getting your payments and getting them paid, because it's going to be difficult, I believe, once you're released, to be able to come up with the money right away. So your first payment is going to be due for both of these cases and the child support in June. Okay, so that gives you over a month to get at least stable enough to make those payments. You have 20 days to appeal. Failing to pay within 20 days means you will lose that right. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. Again, 165 days of jail credit. I have no indication that I need to do an absolute sobriety, but you are going to be on probation. And you are going to be in probation in Minnesota. So this is an imposed and stayed sentence. So you're going to need to, Mr. Fisher, get out, hit it hard, get money, make your payments, and make them timely, because otherwise you're going to just come back here. Child support will drag you back here. And plus that'll have consequences on your probation because you're ordered to pay. Fines and fees and court costs, the court is going to, I'm going to order $518 for the first felony, $250 for the second felony, waiving court costs and fees. That is going to need to be paid separately from your child support. And honestly, you're going to be paying this court, not probation. So you're going to send payments for the amounts due here, not to through probation.
Yep.
And the reason I'm doing that is because then I get to see if you're making the payments with regards to your fines and fees. And if you don't, the court will issue a warrant, and you could sit up to 6 months outside of any of that other time, because the court is ordering that even though they're concurrent together, 23 CF 187 and 23 CF 186 are concurrent together in serving any time, they will be consecutive to any other sentence you may receive in any other case or jurisdiction. Okay. So minimum monthly payments, I'm going to say, I guess I don't know. Are any of you aware of what his monthly payments are going to be for child support?
My understanding is they're going to have to restart it.
Well, the last time it was set at $200 per case. So that was $400 a month. And part of that was going towards arrears in addition to the child support payments for each case.
Okay, so right now, I'm going to accept a minimum of $50 a month to be paid to Burnett County for your fines and fees on top of the amount you're gonna owe for child support, okay? So if by chance you're having a hardship and you can't pay your fines and fees at $50 a month, you have to let me know, and I have to have a hearing with you and figure it out. And I'm gonna tell you at that time, I'll probably throw in a child support hearing. But I'm gonna guess child support is gonna be figuring things out with you, and you're going to be working and talking with Burnett County Child Support. But $50 a month for your fines and fees, again, to be paid to the Burnett County clerks here, and not to probation. I believe that covers everything. We went over address, telephone number, all of those things. Report to probation immediately after you are released. Your DNA will be taken. You may be able to request it be expunged through the system through a written letter to the Department of Justice, not to this court, to the Department of Justice. Easy to do. Google it, or Ms. Fanu can help you. Mr. Vila, what is the court missing?
I don't think you're missing anything, Your Honor.
Ms. Fanu?
Nothing, Your Honor. Thank you.
All right. Good luck to you, Mr. Fisher.
Thank you.
Thank you. We are adjourned. Go on the record in the matter 26 CF 07, State of Wisconsin versus Jose Cheverria. Appearances are we have the state appearing through Jose Vila in person. Mr. Cheverria appears in person with counsel Amber Sherwood. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Ms. Sherwood, can you please recite it for the record?
Yes, Your Honor. The offer would be to dismiss and read in count 1, strangulation, plead guilty to the battery domestic abuse for 60 days incarceration, and to plead guilty to count 3, disorderly conduct for costs only.
Now, what's his jail credit?
His jail credit is 16 days.
So he's looking at going to jail?
Yes, Your Honor.
Okay. Mr. Cheverria, that's the agreement that you've reached?
Yeah, that, I guess sentence, the 2 months or whatever, that's, yeah.
Yes. But you only have 16 days of credit, so you would need to serve additional dates or additional time?
Mhm.
And you understand that?
I understand that, yeah.
Okay, and that's what you're wishing to reach, the
Uh,
agreement?
Yeah. Do you guys sometimes do like, give like somebody like a little bit of time so I can like take care of a few
Yes.
things? All right, cool. Yeah, then I'm doing that, yeah.
Okay. So I have in front of me the plea questionnaire waiver of rights form. Do you recognize the document?
Yes,
Did your attorney go over the document with you thoroughly,
yes,
essentially word for word?
Yep.
And you understand everything completely?
yeah,
Is that your signature on the second page?
Yep.
You're pleading guilty to count 2 and count 3. And Ms. Sherwood, are they both going to continue to have the modifier?
oh, man.
I guess I do not know that, Your Honor. It wasn't
I think it
specified.
would be, one's going to have the modifier, so if you remove the other one, it just makes it cheaper with less surcharge?
Yeah, that's fine, Your Honor.
Okay, so the disorderly conduct, remove the modifier, Mr. Vila,
Yes, Your Honor.
granted. So you're pleading guilty to 1 count of battery with the domestic abuse modifier and 1 straight count of disorderly conduct. You're 35, you have 10 years of schooling, but you can read, write, you understand the English language, all correct?
Yep.
Did your attorney thoroughly go over your constitutional rights with you?
Oh, yeah, she did.
And you understand them completely?
Yes,
Do you need me to go over those rights with you in any more detail?
no,
Do you understand that by pleading guilty, you're waiving and giving up those rights?
yes,
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
yes,
You understand that you're pleading guilty to count 2 misdemeanor battery with the domestic abuse modifier that the state would have to prove on or around January 2nd, 2026 in Burnett County, Wisconsin. You caused bodily harm to MT by an act done with intent to cause bodily harm to that person without that person's consent. And that person has a domestic type defined relationship with you. Do you understand what the state would have to prove?
Yeah.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both? Plus, because of the domestic abuse modifier, it would have an additional $100 surcharge, and it could be the federal prohibition to no longer being able to use or possess a firearm for life.
Yeah, I got it. Yeah.
Do you understand with count 3, disorderly conduct? The state would have to prove that same date, time, and place you engaged in either abusive, violent, or unreasonably loud or otherwise disorderly conduct, which tended to provoke a disturbance. Do you understand what the state would have to prove?
Yes.
You understand the maximum possible penalty could be a fine of up to $1,000 or 90 days of incarceration or both?
Yes.
Do you understand that I'm not bound to follow the agreement that's been reached? That is, I could sentence you all the way to the maximum possible penalty for each of these offenses if I thought it was warranted.
Yes, I understand that.
Do you still wish to proceed and enter guilty pleas?
Yes.
Did you go over the criminal complaint with your attorney?
Yes.
In particular, that section called the probable cause section, where it basically says what happened and why you were charged with these crimes?
Oh, yeah.
For the most part, are those facts accurate?
Yeah.
Are you admitting here today that you in fact did engage in battery and disorderly conduct?
Can I say something with that too?
You'll get an
Okay, my
opportunity.
right. Yeah.
And are you pleading guilty because you are guilty?
Yeah.
Ms. Sherwood, may the court use the probable cause section of the criminal complaint to find a factual basis?
You may.
Has anyone made any threats or promises to you for you to plead guilty
No.
today? You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yeah.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
She answered all of your questions?
Yeah.
You're satisfied with her services?
Yeah.
Any questions for the court or your attorney before I proceed?
No.
As to count 2, battery with a domestic abuse modifier, how do you wish to plead?
Guilty.
As to count 3, disorderly conduct without the modifier, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 counts. Count 1 will be dismissed and read in for purposes of sentencing. Judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. At this point, the court is quite familiar with Mr. Robbery at this point in time. He's been in and out in front of this court for numerous disorderly conduct convictions in the last 5 years alone. This is a case that stemmed from a verbal altercation that escalated into a physical fight, resulting in, bruising on the victim's neck and some destruction of personal property, namely the necklace here. With that in mind, and after receiving victim input on this matter, I think the joint recommendation is appropriate. While Mr. Chavaria is here taking responsibility for his actions, this sentence is necessarily just a punishment for what happened. There's really no other way to spend that one, and making the victim whole by doing the stipulation for the restitution for the property that was broken. With that, all of those factors kind of taken into consideration, I would ask the court to adopt this. Thank you.
Thank you. Okay, Ms. Sherwood.
Yes, Your Honor. I do want to put on the record, we have stipulated to $100 in restitution for the broken necklace. Mr. Chavaria is here taking responsibility. He is doing so in relatively short order, Your Honor. This is not dragged on. This was an unfortunate fight and argument that happened between 2 brothers. Should it have happened the way it did? No, it should not have, and Mr. Chavaria is aware of that. However, he is here to take responsibility. Him and his brother have quashed, for the most part, what is happening in a way that they can. Their family, they understand. Mr. Chavaria's brother does not want more than what is being offered currently. And for that, Your Honor, we are asking that you follow the recommendation. He is going to be punished. He is going to be sitting, as Your Honor pointed out, more time in jail than he has already sat for this, along with a pretty hefty monetary fine, Your Honor. Thank you.
All right, Mr. Chavaria, anything you want to say, you want to let me know?
Oh, yeah. I just want to say that it wasn't bad like that. Battery, you guys, like, come on, what I mean? We did wrestle, what I mean? throw each other around, but there was like no punch or nothing like that to where it got really serious, you know? It's just always pushing with us, you know? But, yeah.
And it gets to the point of
It was
calling
re-
law enforcement.
Yeah, well, mom gets like that too, when, you know what I mean, she gets scared that we're really gonna, you know what I mean? Throw a fist or something, so she's always quick to call the cops, but for real, yeah, no, there was no punch or nothing like that, you know? You know, we were still standing when they got there, you know what I mean? Nobody was on the ground or nothing like that. It's really just, you know, a feud of a stepbrother and a brother, you know what I mean? Just
Live
sometimes.
together in tight quarters.
Yeah,
that
and that, yeah. Stop
un-
looking at me.
that
Yeah, that's right.
Consume either alcoholic or other substances
Mhm.
that it gets heated
Yeah,
and the family wants it stopped.
yeah.
This isn't their first time here. It's not your first rodeo in the
Yeah,
court, and it's not your
yeah.
first rodeo with your stepbrother and or your brothers, or, you know, they've been here before.
Yeah,
Mr. Chevrier, I don't know how to calm things down in your house. I don't necessarily know if like a lot of jail time, I don't know what that's gonna do, honestly. It's just for punishment.
Yeah, for real, just.
I don't even know if your brother wants you to sit 60 days in jail, or if it was reversed, if you would ask the same.
Yeah.
I wish you boys would settle down
I know.
or find a job and move out.
Yeah. Yeah, I'm working on that too. Okay.
Because I'm sure your dad's getting kind of annoyed coming to court too.
I know. Yeah.
He is here almost every single time
Yeah.
supporting you.
Yeah, a little sissy fight it was, just a sissy wrestling match, you know? Yeah, that's what it was.
And I'm gonna guess, well, it was January 2nd, so not long after New Year's. So
Oh,
what
yeah.
could have happened there?
Oh, yeah.
Well, Mr. Chevrier, you are willing to accept punishment. In a case like this, I'm not really sure what the punishment should be. Should it be 60 days? It seems excessive, but the attorneys there are the ones that are reaching the agreement. But I've said this before, I don't want to see you in here again, Mr. Chevrier.
I know. Hey, it hasn't been for nothing bad though, you know what I'm saying? Like, I was bad back in the day,
You were-
I was betting on stuff like that, so, you know, I mean, I haven't had any drug charges or anything like that, you know? I quit that when my brother passed away, so.
I know that's the positive thing,
Yeah.
that you haven't, I mean, the argument of strangulation, suffocation,
That sounds bad.
it makes it sound a lot worse.
Yeah, it does.
And it was with your brother, and so I understand your, I think I have an understanding of your sibling rivalry fights.
Yeah.
What I'm gonna do is, I just know your history, and this isn't as serious as it looks in black and white. I'm gonna sentence you to 35 days in jail. I'm not doing 60. I don't think anything more than 35 is necessary.
All right.
You have 30 days to figure it out and to report.
Okay.
You have 16 days of jail credit.
Mhm.
$100 for the chain for your brother. I'm gonna tell you, you better get that paid, and you better get
Yeah.
it paid off quickly.
So how would I go about paying that? Do I just give him the money, take a picture and send it to you guys, or how do I do it? Or just send the money up here?
Has to be paid now to the clerk.
Oh, okay. I can't just give it around as soon as like that?
You gotta give it to the clerk.
Wow.
Now that it's went through this process, had you have paid him prior to and got confirmation to the state, then they could have said, and the
Ah, man,
restitution's
because I
already
did
been
say
paid.
something, I said something to him a couple days ago too. Dang, all
So
right.
it's gonna need to be paid here, and I'm gonna say that you have 30 days to pay that.
All right, cool. That sounds good. Thank
Okay.
you. Yeah.
I'm only gonna assess $200 in the DNA surcharge. I'm waiving and that's for each count, plus a $100 surcharge for the battery because it has the domestic. I'm waiving all of the other court costs and fees. It's already gonna cost you $500 for surcharges and the $100 for the restitution. I need payments of, are you paying other fines and fees? Okay, well, this one you're gonna start paying and I'm gonna
I
monitor
got you, I
that.
got you. Yeah.
$75 a month. If you fail to pay, I will issue a warrant. You could sit up to 6 months in jail. So you have to start
Okay.
paying this.
Yeah.
First month will be due in June. I'll give you a month off
Okay, June, all right.
because you have to pay that restitution, but you have to make at least $75. Warrant will be issued.
Okay.
Could sit up to 6 months and the civil judgment will be entered against you. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Again, 16 days of jail credit, federal prohibition. If they enforce it, no longer able to use or possess a firearm for life. You're already a felon though, so that really doesn't matter. I just have to say that. I think that covers everything, Mr. Vila.
I would agree, Your Honor.
Sure would.
Nothing from us, Your Honor.
Good luck, Mr. Chavaria. Just be kinder and gentler. And I know I said this before, and this, I don't know if it was with the argument with this brother or the other brother or a different
Oh, that
brother,
sounds bad.
but stop, just walk out.
I know. My pride, man, because, Spanish people, so.
Your pride's taking you
I
to
know,
jail.
Yeah.
So stop.
Yeah. But I
All
am
right.
doing good though. I'm not doing anything illegal, so.
That's good. All right, so I need your DNA. You're gonna need to make sure that the jail has that, but you can either do it now or wait until you report. But again, 30 days to report. If you don't report in 30 days, escape charges can be charged. 30 days, okay? Thank you. We're adjourned. Thank you, Your Honor.
Thank you, Judge.
Senior Chavaria, it's okay if you send him to his room.
Senor Chavaria, it's okay if you send him to his room. Oh, dear Lord. I knew it. Yeah, guys, it's one thing after the other. You know what I'm saying? Probably not. Hey. I did it. Look at that. Did that. So, it's been a long show. For those of you who are not ready to end the evening, we're redirecting over to our favorite little wolf bot. And let me not neglect my friends in chat and make sure that you get a nice little link like that. Because ladies and gentlemen, I'm going to be hanging out there for a little while. Wolfbot has a lot more Fleischer to go. He's been going for 11 hours now. Wow. So thank you very much for coming here and hanging out for the daily court review here on the Court Gallery. We do this every single night at 8 p.m., 9 p.m. Eastern. And, we're going to be doing it again tomorrow. And the day after that, and on Saturday, we'll have a weekend court review, but it's not going to be at night. That's the premiere. The live court review will be at 11 a.m. We're going to do brunch, ladies and gentlemen. That's how we do it around here. And ladies and gentlemen, I just want to say thank you very much. I neglected to bring my little camera down and say, hey, are the dogs like you? Look, she's right there. You can't see her. But they're all here. And we're all saying thank you very much. And I need to boogie on over to this other little transition screen so I can come down here and do this little thing that I like to do, that I just recently gained the ability to do, where I say thank you to all my very good friends, especially Karen X25 Spec, for your generous contributions tonight. Oh my God, if it was not for viewers like you. And all my wonderful stream participants out there who are hanging out in chat and lurking, putting up with stupid ads. Man, Y'all will make it a possibility to help mama and dad out, keep the dogs fed, bring daily court content just like this to you every single day. I thank you very much for it. Ladies and gentlemen, we're going over to Wolfbot, who is showing Fleischer next. We are redirecting there. Slowly, but surely. But for now, I want to say I am your lone Wafoosel. I'm the guy who puts these little crazy things together. And I do it every single day. And we try to find interesting stuff. Mostly education. A little bit interesting. A lot kind of crazy. So come on by. Check on me tomorrow. See what I find tomorrow. I'll be scouring the interwebs for new court cases. And I'll probably be hanging out in Wolfbot too. So come by and hang out in Wolfbot. You can chat with me there while I'm working on getting new court cases put together for everybody. For now, I'll say have a great evening. I'm your lone Wafoosel. I am. BLR. If I could just get Judge Satterfield to say that once, that would be amazing.